All right, everyone, welcome, welcome, welcome. It is wonderful to be here. And joining me, of course, is none other than Diane Howard. And we are so excited, Diane, just to be here. How are you doing?
I'm doing well. How are you?
Awesome. I am doing phenomenal. So we just want to take a moment out to welcome everyone to Soundcheck. I know there's some folks that are joining in online, some folks that are here, some folks that may be coming as well. We just want to welcome you all to our really a workshop in our series of Secure the Bag. And today we're going to be talking all about owning and protecting your music. I am so excited, Diane. I know you've been excited and just getting ready, and
Yeah.
I can't wait. So, just so everyone could, just to introduce Diane and get out of the way here. So, Diane Howard is an attorney specializing in intellectual property law, particularly trademarks and copyrights. And she has experience in both private practice and copyright collectives. Admitted to practice in Jamaica and Ontario, she offers a unique perspective to clients seeking protection and enforcement of their intellectual property. And as musicians, we're going to be talking all about that. I'm excited. Diane holds a Bachelor of Law degree from the University of the West Indies. She also, Mona, a Legal Institute certificate from the Norman Manley Law School, and a Master's of Law degree from Osgood Hall Law School. That's a lot of that's a lot of
It makes
recognition.
me
But
sound better.
listen, you've got some pedigree, you've got some
Oh,
experience
there.
behind your belt. This is exciting. She has successfully represented clients in various trademarks, copyright matters, including registration, licensing, and enforcements. Ladies and gentlemen, let's give a round of applause for Diane Howard. Thank you.
Thank you so much. Thanks for having me,
Thank you,
Joel.
Diane. This is a pleasure. And Diane, I know we've just done the intro and the background, and I know you have a full out presentation and
I do.
you've got everything ready to go. But we always like to introduce the folks that are coming to our programs and facilitating. Uh, why don't you maybe start like this? Why did you choose law? What
Oh
was it
my
about that in
gosh.
your journey that made you say, you know what, I'm going in this direction? What was it for you?
Um, I wish it was a simple story of I always wanted to be a lawyer.
Right.
It wasn't like that at all.
Got
I
you.
actually wanted to do medicine for the
Mm.
longest time.
Interesting.
And then,
Okay.
so my undergrad degree was in zoology, and I realized I really don't like the sciences, and
Got you.
so decided to switch gears and try law. And
Awesome.
I ended up falling in love with intellectual property while I was in law
Wow.
school,
Amazing.
and that's why I've decided to just stick with it, and here we are.
Awesome. Awesome. So that I think so many people can resonate with that story where you might be heading in a certain direction in
Yeah.
life and maybe in your career or in a particular area, even as musicians, right? And then all of a sudden, you know what? Maybe this other route may work a
Yeah.
little bit better for me.
Yeah.
And so it's wonderful that you finally took that step and you landed. And
Thank
I
you.
know you've got an entire presentation, and I'm excited. I just want to get out of the way, Diane, and just because there's so much little nuggets and information that you're going to be sharing. So let me get out of the way, and we'll pull up your presentation and
Yep.
we'll get started. How does that
All
sound?
right. So just starting off, the views expressed in this presentation are my own views. I am dealing primarily with Canadian law. I'm not going to discuss any US law in this presentation because I'm a Canadian lawyer. And this is not to be taken as legal advice. I do have some resources at the end of the presentation that you can use and go ahead and access, but this is not to be taken as legal advice at all. Okay, so I'm going to start off with an overview of copyright law, and then after that, we're going to get a deep dive into music. So, copyright law protects any original, literary, dramatic, musical, and artistic work that's in a fixed material form. So essentially, anything that's not original or anything that's not fixed is not going to be copyrightable. So if you have an idea, but you didn't write it down, that's not going to have any copyright protection. Original means that you have had to exercise skill and judgment in making the work. And fixed material form, it means exactly what it sounds like. It has to be written down, it has to be recorded, it has to be in a permanent form. So, how long does copyright protection last? So, in Canada, copyright protection lasts for the life of the author plus 70 years after they've died. So, when copyright protection, so after they're dead and 70 years plus, their work falls into the public domain. And so public domain means that it's free for anyone to use. So an example would be like William Shakespeare. He's been dead for more than 70 years now, and so anyone can use William Shakespeare's any of his works or any of his notes. So how you calculate it, I have an example here with Elvis Presley. So Elvis Presley died August 1977. So the way that they tend to think about copyright, they're going to put it at the end of 1977. So whatever date you see, you put it for December 1st, 1977. And then you add 70 years to that. And then so his work is going to fall into the public domain January 1st, 2043. And so if you have work that's, joint authorship or something that more than one person has created, it's going to be the work at the last author had died. So it's 70 years after the death of the last author. So in Canada, copyright law gives you two groups of rights. It gives you economic rights and it gives you moral rights. So economic rights gives you the right to produce or reproduce your work, the right to perform your work, and the right to publish your work if it's unpublished. Moral rights, however, give you the rights of paternity. And so that's the right to be acknowledged as the author of the work, or if you choose, the right to be anonymous, or the right to use a pseudonym. Another moral right is the right of integrity. So it's the right to prevent distortion or modification of a work. So no one can edit your work without your permission. The other right is the right of association. So it's to control how your work is used in the public, or what your work is associated with. So an example I like to give is if you have a song and Donald Trump decides that he wants to use that song for his 2024 presidential campaign, you have the right to say, hey, I don't want my work or my song associated with your campaign. So those are your moral rights, and those are different from your economic rights. So your moral rights are your own. They can't be given away. They can't be transferred. But economic rights, you can give them away. So you can give someone else the right to reproduce your work. You can give someone else the right to perform your work. So as I mentioned before, an economic right can be sold, it can be transferred, and it can be licensed. And your economic right really just ensures that you have control of your work and that you can financially benefit from your work. So when you think economic, think about money. And then your moral rights, those can't be sold or transferred, but they can be waived. So once your moral rights are waived, you can't reacquire them. Your moral rights remain with the author. Even if you've assigned your economic rights, you still keep your moral rights unless you've waived them. And so moral rights are more about the creator's relationship with the work, the bond that the creator has with their creation. So they liken it to like giving birth. And moral rights also is a uniquely Canadian concept. It's not found in the US. So in Canadian contracts, you'll see people asking you to waive your moral rights. In US contracts, they're not going to ask you because it's not a US concept. In Europe as well, sometimes they ask you to waive your moral rights because some countries in Europe do recognize moral rights. Copyright infringement. So what is copyright infringement? Copyright infringement is using works that are protected without the person's permission. And so it's actually a very serious it's a very serious concept. You can face criminal charges if you do infringe someone's copyright, and you can also be asked to pay a fine. Now, there are ways that you can circumvent copyright infringement. So they do have exceptions in the Copyright Act. One of them is if you're doing any research, if you're doing any private study, for educational purposes. So, for instance, all the images that I have in this presentation, I haven't asked the copyright owner for permission to use them. So I am infringing their copyright, but this presentation is for educational purposes. So it would be acceptable under the exceptions under the Copyright Act, under education. Parody. So Weird Al Yankovic is very good at parodying different artists and their work. And so he usually falls under the parody exception of fair dealing in Canada. He specifically, even though he falls under that exception, he would ask permission from copyright owners if he could use their work regardless, but he does fall under the parody exception. Similarly, satire, criticism, if you're critiquing something that happened, you do fall under the fair dealing exceptions. Review and news reporting. So you can imagine if someone was reporting the news and every time they were getting hit with copyright infringement claims. So news reporting is one of the exceptions that they have. Another exception that I wanted to talk about today is non-use user-generated content. So it's the remix exception or the mashup exception. An individual can use published or otherwise publicly available work to create a new work as long as it's not for commercial purposes. The original materials were published or made public. You credit the source and the creator of the original materials, and that the original materials come from a legitimate source, and that your new work doesn't substantially impact the original materials. So I wanted to give you an example of what a mashup would be. So this is something you can post on YouTube, and as long as you don't monetize it, you should be okay in terms of copyright infringement, because it's an exception in the Copyright Act. So an example I have here. So that's an example of a mashup that's taking two original pieces of work and putting them together where it creates a new work. Even though you can recognize each individual piece, it does create a new work, and that will fall under the mashup exception for copyright infringement under the Copyright Act. So a lot of times I get the question, like, can't I just take 7 seconds of this 4-minute song and if I use that, shouldn't that fall under fair dealing? Isn't that fair for me to use? And it's about quality and not quantity. So it's not the amount that you use of a song or the amount that you copy of a song. It's about the quality of what you copy when we're looking at copyright infringement. So if you copy 7 seconds of a song, but it's like a very notable 7 seconds, it's not going to fall under copyright infringement. You're not going to be able to get fair dealing from that. So courts have emphasized that infringement is qualitative and not quantitative. So a single image, any amount of text, it may still infringe copyright because it represents a substantial part of the skill and judgment. Another important thing to note is your limitation period. So all infringement actions must be brought within 3 years from the time you ought to have known about the infringement. I'm going to give you an example of what that means. So I had someone come to me once and they said, hey, I made a beat. I placed it on SoundCloud. And a couple months later, I heard Drake and Rick Ross with the same beat. So I asked them, okay, when was this? They said this was in 2009. They came to me in 2023. And it was a really popular song that was released. So I asked them, like, didn't you hear? You must have heard the song. And they're like, yeah, I heard it. I just didn't bother to ask, I didn't bother to ask about infringement, but I want to ask now. But the point is that they knew about the copyright infringement from 2009. So they would have had 3 years from the moment that they had knowledge of that copyright infringement to do something about it, to sue whoever they wanted to sue. So it's 3 years from the moment that you knew or you ought to have known about the act of infringement, not 3 years from any time. It's a blank 3 years. Now that's in Canada. In the US, they have different rules. I'm not going to go into that, but in Canada, it's 3 years from the moment you ought to have known.
Oh, like let's say you found out that someone used your work like way later.
Mm-hmm.
How does that work?
If you found out for the first time, 10 years later, that someone used your work, it's 3 years from the moment you knew. So it's your knowledge. When you became aware that your work was being infringed, your timer starts 3 years from that day, even if it's 10. Even if you found out 10 years after. Yeah. So we have some infringement examples that I just wanted to play so that people get an idea of what might be copyright infringement, what isn't copyright infringement. Go ahead.
And if you feel like I feel, baby, and I'm thinking about how. Come on. Oh, come on. Woo.
Let's get it.
So that was actually Marvin Gaye and Ed Sheeran. So recently Marvin Gaye's estate sued Ed Sheeran for copyright infringement. And I was just curious if anyone thought they heard anything that would indicate that Ed Sheeran, copied Marvin Gaye's Let's Get It On. Did you hear?
Sounds pretty close to me.
Sounds similar, which it does sound similar, but the court ended up finding in favor of Ed Sheeran, and they found that the Ed Sheeran's defense really was that the chords are a common progression in any music song, and so yes, it wasn't that he directly copied. He didn't directly copy anyone, but it's something that as a guitarist, you're going to use those common chords regardless. So they actually found in favor of Ed Sheeran. I think they get the idea. So from that, does anyone have any idea of whether or not Pharrell was infringing copyright? I think we're pretty familiar with this case. It could be argued. So in this case, the court found that even though Pharrell Williams and Robin Thicke didn't directly copy Marvin Gaye's song, there was enough of a similar feel to warrant copyright infringement in this case.
Here you were, you were gonna come to me. And here you are, but you better choose carefully. 'Cause I'm capable of anything, and
You know what it is? Let's talk about it. Your boys.
All right. So does anyone think that was copyright infringement? A little bit of a reach, and the judge agreed with you guys. It was a little bit of a reach. They said that the rapper was attempting to claim improper monopoly over conventional music blocks, and that the song was it consisted entirely of commonplace musical elements, and any similarities between them do not arise out of a combination of these elements. So it was a little bit of a reach, and it was found not to be copyright infringement in the end, but it did go all the way up to the Court of Appeal.
Yo, VIP. Let's kick it.
Okay, so what do we think about that one? I'll show you the difference. It was literally a one note different. That note that's just circled in red, that's the only difference between Ice Ice Baby and Under Pressure. So this one didn't actually go to court. Vanilla Ice ended up just settling out of court because I think he knew he would lose. And he ended up paying Queen, I think it was $4 million for the use of the work. So yeah, those are some examples of infringement examples. Okay, so do I need to register my copyright for my work to be protected? And no, you don't need to register your copyright for it to be protected. As soon as you make the work, it is automatically protected the moment that you create it. If you want to register your copyright on the Canadian Intellectual Property Office, or with CIPO is what we call it, it's entirely voluntary. And by registering your copyright, you receive a certificate that's issued by CIPO, and you can use that certificate in court as evidence that you own your work. So I do encourage people to always register their copyright, but it is automatically protected the moment that you make the work. CIPO, the CIPO registration fee, so for each work, it's $63. So it's not that expensive at all. I'm just going to give you a small walkthrough of where to go on the CIPO website. So as soon as you go into the Canadian Intellectual Property website, you scroll down and you go to register a copyright right there on the right. And then you go all the way down and then you click on log into the copyright e-filing application. Yep. And then at that point, you're going to create your own login. So once you do create a login, and I'll just slowly walk you through the things that you're probably going to need. If you could enlarge that a little bit, Joel. Okay. So the first thing you're going to do is just enter the title of your work. And it's your title, whatever you choose. You're going to select a category, and whether that's a literary work, a musical work for people at Soundcheck normally, artistic work, dramatic work. And then the next is publication. So sometimes your work is not going to be published as yet, and publication would mean like you've made it public to the world. So your work might be unpublished, or it might be public, and you just check whichever box it is. You put the date of publication, and then you put your city, town, province, state that you had the work published in. And then you go to ownership. So who is the owner of the work? You enter your name. An owner can also be a legal entity, and you just put your mailing address, your telephone number, and you just fill out the information as you go. If there's more than one owner, there'll be a prompt where you can open up to put additional owners. So it doesn't just have to be one person that owns the work, it can be multiple owners. Scroll down a bit, Joel. And then you have the author. So the author is a person that made the work. So in Canada, you usually have a human author. And And so you can actually put a pseudonym because, as I mentioned, as a creative, you have the moral right to use a pseudonym if you wish, or you can use your legal name. It's up to you, whichever one you feel like. And then you just enter your correct mailing address as well, and you enter your telephone number, scrolling down a bit. Then you just do a quick declaration that you are the author of the work, or you are the owner of the work, or both. And then if you can do it yourself or you can pay an agent to do it, I encourage people to do it themselves because, as you can see, pretty simple. And you just pay your fee of $63. And you do that per work. So for you guys, it would be per song that you would do that for. And you submit, and that's it. And that's how you get a copyright registration. Is there a way to check if your current work is infringing copyright law? And no, there's no way to really check. It would be on the person that is claiming infringement to be the one to come forward and say, hey, I think you're infringing my work. I wouldn't, as a creative, go out there to look to see if I'm infringing someone's work, but I appreciate that maybe you want to be ahead of the game, but you should also know if your work is original or not, and if you made it or not. So no, there's no way to check. Someone will contact you if they feel like you're infringing their work. Perfect question. So what is the benefit of registering your copyright if it's automatically done? And that's only if you think that someone is infringing your work, and so if you made a song and you register it and you think that someone is infringing copyright, you're able to stand up in front of a court to say, hey, I actually have the copyright registration. And so the court is going to take your evidence more seriously than someone that doesn't actually have a registration. So it's really just in the event that there's a claim of copyright infringement, the court is going to look at your evidence more favorably because you actually have the paper to say, hey, I have registered the copyright, as opposed to someone that doesn't. So it's really about evidence in the event that, you have to go to court to defend a copyright claim.
Does having a copyright registration mean that you can't have a claim of infringement coming against you? Can somebody still say you copied their work if you have a copyright in your work?
Yeah, so when you actually go to SIPO and you fill up the form, you're not giving a sample. So SIPO actually doesn't know whose work came first, whose work was created first. So you can still have someone claim copyright against you. The court is just going to really take your evidence into consideration more because you end up having the actual registration to say, hey, I have a registration certificate. So it's just you're just looked upon more favorably, but someone can still come to you and say, hey, I think you're infringing copyright, even though you have a copyright certificate. All right, so common questions I get. Is mailing myself a copy of my work the same as copyright registration? And no, mailing yourself is not the same as copyright registration. It's not a form of copyright registration. If you want to mail yourself your copyright, you can, but it really doesn't do anything. It's not thought of as evidence in front of the court. Really, the only evidence is the copyright certificate that you get, and it's not going to be given serious consideration if you go to a court saying that I mailed myself something. The next common question is, do I need to mark my work with a copyright symbol? So in Canada, there's no requirement to put a copyright symbol, which the copyright symbol is a little C with your name and the year that you wrote, the year that you created the work. And there's no requirement in Canada, but in some jurisdictions, it is required that if you have copyright, you would put the C on it. So I encourage people to always put the copyright symbol just there, even though it's not a requirement in Canada. It's important if your work is going to another jurisdiction, you want to make sure that you have it there. And it does serve as a deterrent. So if someone sees your copyrighted work and they see the copyright symbol there, it puts them on notice that it makes them pause if they want to take it. Let's put it that way. And you can use that symbol whether the work is registered or unregistered. So we're going into the juicy part, which is music. What everyone wants to hear, and that's why everyone's tuning in, I know. So songs are made up of two parts. When you hear a song, and this is from now on, I need you to think of it in two ways. You have to think of the musical composition, which is the notes and the lyrics. So the musical composition is anything that is written or can be written down. So anything that's in a sheet music, a book that you've written your lyrics in, that's the musical composition. And that's one part of the music. The other part of the music is your sound recording. And that's your master. And that's just the recording of the musical works. And you have to remember that for the rest of the presentation. So you have your musical composition and you have your sound recording. So music is split in two. Let's think about this song, I Will Always Love You. Dolly Parton was the songwriter. So she's the one that came up with the lyrics. Then you have the person that performed the song on the other side that made the sound recording. And that's Whitney Houston. She's a recording artist. Now, you have four major groups of rights holders when it comes to music. You have the performer. In this case, it would be Whitney Houston. You have the maker. Now, a maker is a person that arranges the sound recording. So anyone that books the studio, pays money for the studio time, anyone that employs a session musician, that's somebody that is the maker. That's what we call it in Canada. We call it the maker. Usually that's going to be your record label. That's usually the person that's the maker. But if you're an independent artist and you booked your own studio session and you paid for everything yourself, you're the maker. So you have the performer and you have the maker. Next, you're going to have the songwriter, and that's pretty easy. It's the person that came up with the musical work. So somebody came up with the lyrics, someone came up to the melody. Those people are your songwriters. And then at the end, you have your publishers. And those are the people that buy the musical work from the songwriter. So anyone that owns or co-owns the rights to exploit the music, that's going to be the publisher. So as I mentioned, if you're an independent artist, you're the one who performed. You wrote the song, you performed the song, you're the one that published the song, you're the one that did the studio session. All of these four rights belong to you as an independent artist, but obviously it can become complicated when there's a record label involved. So in this case, we're going to see Dolly Parton, songwriter, Whitney Houston is the performer. The publisher in this case was Velvet Apple Music. They partially own the music composition so Dolly owns some, Velvet Apple Music owns the other part. And then the record label in this case, which I mentioned, is the maker, the person that put everything together, the person that got Whitney with the band. That is Arista Records, and they actually own the sound recording. Yeah, so their rights would be they would get performance rights. So anyone that performed on the sound recording and like a background vocalist or a band member, yeah, they would get or even the main person that sang the song, though they have performance rights. But if they wrote any lyrics, if they wrote any melodies, if they wrote anything, they also have songwriting rights or composition rights. Yes, they can be considered a composer if they make musical contributions, but it gets a little bit more complicated because it gets, I'm going to go into that a little bit later about what's considered a significant contribution and whether or not they would be given like songwriting credits or co-authorship credits. I'm going to get into that a little bit later, I promise. Yeah. So, Yeah, just to finish this off. So we have Dolly Parton, Whitney Houston, we have the publisher, Velvet Apple Music, and we have the record label, Arista Records. So what I want you to consider now is the rights and where you would go. So if the song is reproduced, Dolly Parton would get some licensing payments from the CMRRA, which is a copyright collective. If the song is publicly performed, she would get some royalty payments from SOCAN. And then on the other side, if the song is digitally performed, then they would get some. Whitney Houston would get some licensing royalties from Resound. And so I'm going to go a bit deeper now into Resound, CMRRA, SOCAN, and the royalties that you get. Okay. So as I mentioned before, if you are an independent artist, you're going to own all four of those rights. You're going to be the songwriter. You're going to be the music publisher. You're going to be the performer. You're going to be the maker. So it's important that what you do when you're even a session player, you're a performer, you keep a detail of what music you have contributed to and when. You want to sign up with the appropriate collective societies so that you get in the habit of registering your music with each one. And so if there are any royalties owed to you, they'll contact you and they'll pay you. So I have a chart here regarding copyright collectives. So on one side, you have collectives for the musical works, so the sheet music. And the collectives that deal with that is SOCAN and CMRRA. At this point, they're pretty much identical, and they give songwriters and music producers, songwriters and music publishers. They're the ones that give royalties to songwriters and music publishers. On the other side, you have Resound, Connect, and MROC. So those are the collectives under Sound Recordings. And so for Resound, you're going to get royalties for the makers. So whoever, that can be a record label or an artist, if you own your own sound recording. For Connect only deals with record labels, and they give royalties to record labels whenever there's reproduction of a song. And MROC, which I think is very important, gives royalties to performers. So any background musicians and session musicians and vocalists, MROC would be the person that's paying you your royalties. So I have a few examples, a few scenarios that we can go through so that you kind of get where everybody falls. Okay, scenario one. You're an independent singer-songwriter. You wrote lyrics to a song. An independent songwriter wrote lyrics to a song and asked you to play lead guitar during a studio session that she's paying for. So you composed an original melody and you played it as she sang on the sound recording. So what royalty entitlement do each of you have? So let's start with the singer-songwriter. If you could go back to that chart, Joel. So she's definitely going to have songwriter royalties. She's also going to have performance royalties. So she's going to get royalties from MROC. She's going to get royalties from SOCAN. And in this case, she's also the maker because she's an independent, she's an independent person she's the one that's arranged for the sound recording. And so she's going to also be able to collect royalties from Resound. So those are the three for the singer-songwriter. And then, thanks. Then when we go to the guitar player, if you could go back to the slide. So the guitar player also wrote the melodies for the song. So they would get SOCAN royalties. And they would be a performer as well. So they would get MROC royalties. Hopefully that makes sense. And I don't know if anyone has any questions so far. Okay. So next scenario. Okay. So you're an independent singer-songwriter asked you to provide background vocals for a song they wrote during a studio session that they arranged and they paid for. So the singer-songwriter, if we could go back to the chart, they're gonna get songwriting royalties. They're gonna get sound recording royalties. They're gonna get maker royalties from Resound as well. And they're gonna get performer royalties from MRock. So if they ask you to sing background vocals, you're going to get MRock royalties from MRock as well. I'm not sure if that's making sense to everyone. Okay. Okay. So co-authorship. So this goes to the question that Joel was asking about what is considered a co-author. How much do you have to put in to be considered a co-author? So when a song is produced by collaboration of two or more authors, in which the contribution of one author is not distinct from the contribution of the other author, it's considered joint authorship. So if you write a song with a co-author, unless you sign an agreement, it's going to be that you both jointly own the song. So even if they wrote, the lyrics and you wrote the melody, it's considered like both joint ownership, unless there's an agreement in place that says otherwise. So in Canada, the law isn't exactly clear on how you become a joint author. There's one line of cases that say joint author of a song needs to establish that they made some significant original expression to the song. And then there's another line of cases that said, yes, you have to make significant original expression to the song, but each songwriter needed to have intended to be a co-authorship. So there's no line of cases in Canada that's necessarily correct, and they're both existing at this time. And so the law itself is a little bit muddy as to when you'll be considered a co-author. But generally, if you give any significant expression, original expression to a song, you're going to be considered a co-author. And so one of the things I always encourage people to do, if they didn't intend to be in a co-authorship with someone, when, they invited someone into a room, everyone's just laughing, everyone starts talking, everyone starts writing stuff down, and we're jamming together. If you don't intend for that person to be your co-author with you and you're making your own song, you need to put that in an agreement. Next slide.
Someone asked, what if they only write the chorus, but you did the rest?
Yep. Only write the chorus. Yeah. So I'm not very musical, but I'm guessing the chorus is a very big part of a song because it's usually the hook. And when someone writes a chorus, they're still going to be considered the co-author with you. So if you didn't have an agreement in place, it's going to be a 50-50 split. You're both co-authors. So you both jointly own that song.
The next question, is there a way to split it?
Yeah, of course.
5%, 75%?
Yeah, that's on my next slide. Okay, so to be safe, write it down. That's how you split it. When you're in place with people, you can sign a co-writer agreement, and it clarifies certain things. So one of the things that you can clarify is your your co-authorship split. So you can have it written down in the agreements that hey, I wrote 45%, you wrote 25%, I added 30%. And so that split, though, that you've written down, that's usually how the royalties are going to end up being split as well. So you have to be mindful of that. Another thing that you want to have in your co-authorship agreement is signing authority. So if you have 5 members of a band, and I've seen this happen, some people, 5 members of a band make a song. One person decides that they want to leave the band. The other 4 people got an opportunity to actually work, get to have license their song to a movie. And unfortunately, the one person that left the band just didn't feel like signing. And so they actually lost out on that opportunity. So one of the things that you really want to make sure you have in a co-writing agreement is to make sure that only one person has signing authority, and that it's, if not, it's going to be all five of you that need to sign. If it's five of you that made the song, all five of you are going to need to sign over any rights to the song. Another important part to have is who can perform the song and who can record the song. So you want to just have it in writing, whether it's going to be, hey, all three of us can equally perform the song, or only one of us can perform the song. The use of name and likeness. So Joel, if you and I wrote a song together and I decide to go out and market the song, can I say, hey, it's Diane Howard and Joel Reed's song? Can I use your name? Can I use your likeness to market the song? Or if you don't give me that permission, can it just be me? Can I just be the face of the song? The right to make alterations. There's some people, you've made a song, you've created a song with a group of people, but maybe you want to change something. Maybe you want to add a couple notes. Maybe you want to change a melody here and there. You have to put the right of alteration in your co-writing agreement. And the final part of what you really want to have in a co-writer agreement is have everyone sign that what they contributed to the song was original. Because in case one person actually heard something and copied it and placed it in your song that you thought was original. So you want everyone to sign, to just sign off to say, hey, my contribution to this particular song was original. And so if you do that down the road, you're not going to have many disagreements, because everyone's authority, everything is cleanly set out. And I do encourage people to try to get a lawyer to have the co-writer agreement, but I know that's not always possible. So that's why I gave you a few helpful hints to know what to look for in a co-writing agreement. Okay. Are there any questions, Joel, on co-authorship, co-writing agreements? Yeah.
So what if they sign even though it's not original?
Then you have recourse to sue them. So the question was, what if they sign to say that what if a band member signs and said what they added was original, but it wasn't original? So yeah, they can be sued. You can sue them as one of the band members. Yeah. Any other questions?
Not at this time, it doesn't seem.
Any questions from the crowd? No? We good? All right. So, licensing. So, as I mentioned before, one of your economic rights, you're able to license your copyrighted work if you want to. So, a license is granting a limited granting of certain rights for someone else to use something that you own, and in this case, it would be a song. Licensing, you can license for music use in films, television shows, video games, streaming services, downloaded services, physical sales. Those are negotiated directly with the independent artist or the record label. So if a TV show wants to put your song in an episode, you're going to need the two licenses. So you're going to need the license for the musical composition, and you're going to need the license for the song recording. So when you license a song, there's some of the terms that you have to look out for in licensing agreements. So one of those is media. So, what are the different outlets that your song is going to be used in? Are you going to be used on you want the agreement that you have, the licensing agreement, to be specific. Is it going to be on the internet? Is it going to be in a TV show? Is it going to be on the ad? And if it's on the internet, is it YouTube? Is it streaming services? Is it social media? So you want to be as specific as possible when they're talking about they're going to be using your song in all media. So you want to ask question, what's the media? You want to look at the term of the license. That's how long the license is going to last. Is it going to last for 1 year? Is it going to last for 5 years? Is it going to last in perpetuity? In perpetuity means forever. And so if you end up having, if you sign a license that says, the term of the license is in perpetuity, and then your song ends up blowing up, you can't ever go back to them and ask for more money, more fees, or anything else, because they still have the licensing rights forever. And so the next one that you want to look at is territory. So where will they be able to broadcast? Are they broadcasting only in North America? Are they broadcasting only in Canada? Are they broadcasting, worldwide? And so you want to look at what the territorial component is. Exclusivity. So most licensing agreements, they state that they're granting rights on a non-exclusive basis. Some licensing agreements do say exclusivity. So one of the things, if someone comes to me and they say, hey, I have a licensing agreement and they want to exclusively use my song in a potato chip commercial, what you can maybe negotiate with them is like, okay, so they have the right to exclusively use your song when it comes to food or for a certain product. But maybe if someone else comes to you, that comes from, I don't know, like Ford or something like that, and they want to use your song, maybe so you want to look, if there is exclusivity, you want to try and narrow it down to exclusivity in that particular industry, as opposed to general exclusivity, so that you'll be able to use your song for another type of industry in that case. Hopefully I'm being clear. Fees. So you have to, again, look at both sides. You have fees when it comes to musical composition, and you have fees when it comes to sound recording. So if Netflix comes to you and they say, hey, we want to give you $5,000 all in, that means that they're giving you $5,000 for both the musical composition and the sound recording. In the event that you have a record label, then you'll be only getting $2,500 for the musical composition, and the record label will be getting the other $2,500 for the sound recording. And so one of the things you want to look at is whether it says, if it's both sides that you're getting the money for, if you're an independent artist, and that's going to be they're going to call that the all-in fee. And then the final thing that you want to look at when it comes to music licensing is your moral rights. So Canadian licensing agreements usually have express language asking you to waive your moral rights. And the reason for that is that if someone is licensing your work and they end up editing your work, they would have to come to you every single time they wanted to make an edit, and that's just not feasible. So they do usually ask that you waive your moral rights so that they can manipulate your work how they want to.
Does that mean you can't object to the final product?
So you can so the question is, can you object to the final product? So what you can do is waive your moral rights, but ask for approval rights for the final product. Yep. Final slide. Okay. So Artist Legal Advice Services, or ALAS, it gives you free summary legal advice and information for any creators. And so you actually get a 30-minute consult. You can go to the website, Joel. So if you do have any legal questions, if something is, if you've been considering, it's the very last link. No. Yep. Yeah, if you do have any legal questions and you want to speak to someone, you want to speak to an actual lawyer that knows, that's able to help creatives and knows about copyright and knows about music law, you can actually go to ALS and they will offer you support. And if you scroll up, I'll show you how. So you just go to Legal Clinic. That's in the right-hand corner. Yep. And then you can scroll down. There's a client intake form. And you can go through, you give them your name, and you give them all the information, email, phone number. You'll get a 30-minute consult on Zoom, and you just give them as much detail as you can as to what the issue is, and you'll be able to book yourself a Zoom session with a qualified lawyer, and they'll be able to help you. And that's the end of my presentation. Does anyone have any questions?
So typically, again, folks may be approached by a producer, so someone who was hired probably by the artist or
Okay.
the artist's representation, to compose the musical elements of their song.
Mm-hmm.
And perhaps they may or may not play a part in the actual written lyrics,
Mm-hmm.
but they definitely would play a part in terms of the musical composition. And so said person would then seek out, performers to record, so he or she would probably lay out a foundation of what they're looking for,
Right.
and then hire people to deliver that.
Mm-hmm.
But in some cases, for example, I'll use guitar players for example, because I'm a guitar player. But in some cases, guitar players, there's not a whole lot of guitar-esque things going on.
Mm-hmm.
So it's like you'll hear the song, maybe there's keyboards
Yeah.
in what you're being presented. Maybe
Mhm.
there's a drum track, maybe there's lyrics, maybe there's not. But then as a guitar player, you're coming in and you're creating completely original stuff that has often nothing to do, with it's completely original to
Yeah.
everything else that's going on. So how would can you speak to that at all, or kind of?
Yeah. So it's going to depend a little bit on whether or not there is an agreement in place.
Right.
So I don't know if the producer, when they're engaging the guitarist, like
Right.
if they had an agreement with each other, or if someone's just say, hey, come on in, and
Yeah, like, because like just hearing from folks and different things, sometimes it might be, hey, we're writing this song, or we're almost done, we need some guitar parts,
Right.
here's the fee for doing it.
yeah.
Can you get it to me by
Yeah.
such and such a time, like that kind of a thing?
And and then the guitarist makes a really original composition and puts it.
And puts it exactly, so adds.
So then they
Mhm.
would have to, in my mind,
Mhm.
unless there is a written agreement,
Right.
they would have composition rights.
Interesting.
In my mind.
Very no, interesting. Yeah, no,
Yeah.
that's very interesting, because I and so how would one I guess that's what you were talking about, agreements and having
Right.
everything in writing,
Right.
right? Because then you're
Then
able
things
to.
can get really murky, and
Right.
then you have to, you're gonna have to go and have a conversation that's probably gonna be a little bit uncomfortable to say, hey, I wrote this, I contributed to this,
Yeah.
the song blows up, and I wrote this and I contributed to this, and I haven't seen a penny for it. Like, what's going on? Is it registered? Did you register it with SOCAN? I heard
Right.
it played on the radio a few
Right.
times. Like, what's going on? Like, you have to have those conversations, and that's why it's always imperative. Like, I know, listen, a lot of music historically has been done through handshake deals.
Mm-hmm, mm-hmm.
And we kind of have to get out of that at this point. We're not there anymore. You have to put things down in writing. And maybe that's just a lawyer and me talking. You walk into a room, and you're contributing to something. You have to be able to say, hey, maybe we should put this down in writing, guys. Maybe we should say who's writing the composition, who's writing the melody, who's writing the lyrics, and just have a split. If you only want me to get 10%, it is what it is, and I'll take my 10%. But at that point, at least, if it blows up, you have 10% of royalties that you can collect.
Got you. And I'm curious about this a lot, because often I don't remember the specific term that you used, but I'm gonna just use my term,
Okay.
like significant contribution or whatever.
Yes. So significant original expression is
Right.
what the law is as to what would make you a co-author.
Got you. And so the reason why I'm going in that direction is
Mhm.
because my question is, so let's say if said person is because when the song got created, you're not entirely sure, like you know what you contributed,
Yeah.
but you know it sort of it's how the song grows and the popularity and
Yeah.
often how the song is even received,
Mm-hmm.
because like often there's songs that are note what makes a song recognizable, it might be a part that you played
Yeah.
that actually
Yeah.
makes the song like iconic or
Right,
recognizable,
right.
or you know what I mean. And so but you knew it was a great part, but maybe you didn't know it was that iconic, because you know what I
At the
mean. No one,
time.
yeah,
At
because
the
no one
time, you
heard the
don't know at
song.
the
Yeah,
time,
you
yeah.
don't know. Are people gonna? Is this song gonna go far? Is it not?
Yeah.
Right. So I'm just curious about like how. I'm just curious about your thoughts on how to navigate sort of through that. I know
Yeah.
it's there's a lot of layers in that question, but
So I can
Yeah.
only speak legally because I'm a lawyer.
for-
But I can. So when it comes to significant original expression,
right,
it has to be something that's not trivial. So there's some people that will come in and they'll hit 2 notes or something like that and just be like, "Hey, I contributed," and it's
Right.
like, and that amount of contribution on a song is not gonna make you an author.
got you.
I don't recall any case law as to what is considered a significant original expression, but it can't be trivial. So there's no amount. I can't say 4 seconds.
Right,
You know what I
right,
mean? I
right.
can't say, but if it's so in your example,
Right.
you're saying, hey, this is what ended up making it
Yeah,
iconic.
like if there's a
Right.
song and like the
Right.
part everyone knows is like the part that you
Right.
played,
Then
right?
that's significant.
Right.
That original expression that you contributed ends up being significant, and so
Right.
there in that situation you would be considered a co-author.
Interesting.
And so if there and again, if you didn't have anything set out in terms of
In writing,
in writing,
you're automatically
right, it's all
Right.
you're automatically like part of that co-authorship, and there's no,
Interesting.
it's almost like you crack an egg.
right.
There's no difference between this is the yolk and this is the, you know what I mean. It's all
It's kinda all there.
gelled together when you're a co-author.
Got you. Interesting. There's a question here.
I was going to build on Joel's example. So if I'm somebody who thinks I did the best guitar line on a song and now everybody thinks it's a really big deal, can I just go file a copyright and say, hey, I'm a joint author without the other person knowing or being, I don't know, because I think where Joel might have been going and where I start thinking of this thing is, well, how do I get to assert my rights? How do I get from, hey, I really think I contributed this on this song to I'm going to get fairly compensated for it. So it's one of the techniques.
So I mean, just to answer your question about do I just go and like get a copyright registration, I've seen people do that, just going to get a copyright registration without having a conversation with their band members. And it always causes problems at the end of the day, because it's everyone, someone's going to feel slighted, someone's going to feel upset. And so if you feel like you've made a significant contribution, I think one of the things you're going to first have to check is if the song itself is even registered for you to be able to collect royalties. Like, does SOCAN, does CMRRA, do they have a registration of your song? If they don't, then I think the best thing to do would be to have a conversation with the people that you created the song with, to say, hey, I'm going to register this. I'm going to put myself, put whoever as co-owners or co-authors on this, and then we can collect royalties together. If there is an issue, then they'll have a conversation with you. They'll let you know there's an issue.
So what it seems like you're saying is if it's kind of hard to avoid the argument.
It's hard to avoid
if you
the
don't
argument.
have the agreement in advance.
If you don't have the agreement, it's going to be difficult. They're going to be difficult conversations that you have to have. And also, like I said, I have seen people go right to CIPO and register a copyright and only put themselves as the owners or only put themselves as the authors, and their band members are like, what's going on here? Like, why didn't you register us as well? What happened? And so it's a lot of uncomfortable conversations that you have to get comfortable with having. So in an agreement, like, is there a way to just say, hey, we all contributed 33.33%? Is that what you mean? There's no so one, if you don't have an agreement and there's three of you, it's going to be split equally. If you do have an agreement, or you're trying to make an agreement, that's something you're gonna have to discuss as to how much I made, how much of the song I'm contributing, and even before making the agreement, you can have that conversation in the room of, hey, this is my song. I think I've done the heavy lifting. I've done 90% of the work. I think you've only done 10. So there's no default way of splitting it unless there's no agreement. Then it's all equal. Hopefully that answers. Oh, how to have that discussion? That's gonna depend on the room, right? Like, that's gonna depend on what actually happened in the room, like who contributed what in everyone's opinion, as opposed to I don't think there's any fair way to discuss it. Or you could just say, hey, we're all equal band members and we're all gonna do this equally regardless, and just put everybody down as equal. Yeah, just put it all down as equal from the jump, and just say, hey, we're all part of this, and so we're all doing this together, and so we're all going to equally be considered co-authors. You can just do that from the very beginning, and then just make the song. But you have to be ready for the difficult conversations of, hey, I don't think you contributed enough. I think I contributed more than you.
But no, this is great, Diane, and it's funny because, like, there's so much, like, you think about all the famous bands and fallouts and disagreements, and what is it always over, right? Like, stuff like this: who contributed what, and who should be getting rights and who's not, and that kind of thing. And it seems like, just based on the structure, what you've explained, like, it's almost like it's inherent, right? Like, just by you going into a room and creating something, there's automatically assigned rights without people really being aware of what's going on, and like something just happening like that without people necessarily talking about it can obviously lead to misunderstandings, right? I didn't know that. I didn't want you to be a co-author. Like, I didn't, what I mean?
That's
like,
always a big one. I didn't intend for you to be a co-author on this. That wasn't my intention. I thought we were just talking.
Right.
Like,
I called you here to play guitar. Like, you know
what's
what I mean?
going on?
It's like, but no, this is really, really, really helpful. And I think that even that chart that you showed where, people can, even going back, because we're going to have this up and folks can kind of go back and look, oh, here's this rights agency that I need to make sure I sign up with, or, and do each one of those rights agencies need the copy of that that you registered, that you mentioned, or
they don't need you mean a copy of the work?
Yeah, well, the registration of it, because I know you meant. Remember,
you have to sign up with each one individually,
right?
Like, if you sign up with SOCAN, it doesn't mean that MROC has your information or anything like that. So you do have to know where you fall. So if you're a songwriter, you have to sign up with SOCAN individually.
Got you.
If you're a vocalist, you have to, and it's up to you. It's up to the person,
right,
to take on the responsibility of signing up with each one themselves.
Got you.
Yeah.
And then when the song, because I remember you walked us through how to actually register the work. And so
that's
do
for
they?
Copyright.
Okay, that's just for copyright.
That's just
Got
for
you.
copyright.
Got you.
Yeah.
Perfect. All right. So are folks following so far? Is this kind of making sense? Are there any other questions?
What if I walk into a studio and I call a guitarist, a drummer, a bassist, all of them into the studio, but there's no origination from them? It's all my original idea, and I tell them exactly what to play. I just can't play the instrument. What is the split at that point? Or is there even a split? Let's say we were going into an agreement. Do I have to make that an agreement?
You always have to make everything an agreement.
Okay, so I want it all for me. I'm telling you exactly what to
Right.
play. I'm telling you exactly what
So-
tempo to play the
Yep.
drums at, everything.
And so what I would encourage that person to do is from the outset have the musicians sign something that says that they're not originally contributing to the work and that they're not co-authors in this work and they're not authoring the work in any way.
I have to convince people to sign it then.
Yeah.
Is there any other questions that in the room?
Every artist has like different genres, right? Like
Genres, yeah.
like even like you can be a beginner, you can be like a professional, like
Mhm.
everything you want to be.
Mhm.
But what stage do I have to be for me to be able to like be like, yes, I need a lawyer now
Ooh.
as an artist?
Ooh.
Like
Good question. So I guess it's going to depend, right? It depends on what you're trying to do. So at all times, I'd say if anyone ever presents you with an agreement for you to sign and you read through it or you have questions, you don't understand it, I would say make the effort to maybe reach out to ALAS, send them a copy of the agreement, have them review it, and they'll tell you if there's anything that stands out. You know, if there's anything that they're like, hey, I'm not sure, or maybe you should go back and negotiate this. So you can definitely use that legal service for those types of questions. If you're just like, hey, I'm not sure if this is something I should sign. This is not something I'm comfortable with. I don't understand this particular clause. Can you explain it to me? You can do that. Otherwise, if you're a beginner, I'm not sure how to answer that in terms of how advanced you have to be to get a lawyer. But I do think that if you are presented with someone with an agreement at any time, definitely reach out to have a lawyer look at it. Yeah.
Another question coming in here.
I know that music is sort of done differently these days. And so if I go and, for example, play somebody else's song, but try to put my own spin on it, reinterpret it, and then I post it on YouTube or on my Instagram or whatever, am I infringing? And what might happen to me if I were to do something like that?
So specifically YouTube or just social media?
Call it general social media. So I put it on all my socials.
Okay.
But I didn't release the
So,
song or anything like
I'm
that.
not sure if you were there earlier.
I may have missed that.
We did talk about mashups and remixes. And so is that what? But you're more.
I'd say
you're
maybe it's more of a
talking about-
cover. Maybe it's like an instrumental cover. You know, I went and played and sang somebody's song on the piano, and I made maybe some changes to the song, but I didn't combine two different songs together.
Mhm.
I sort of just put my own spin on a song and put it out there to my socials.
Okay. So for instance, you might be flagged on YouTube for putting your own. If it's a song that's recognizable and it's copyright protected, you might be flagged on YouTube. There might be a way that the copyright owner might reach out to YouTube. They might ask that the actual song or whatever you place on YouTube, that they can monetize it. You won't be able to monetize it. And if they think it's infringing enough, you didn't put enough of a change on it, which generally it doesn't even matter. It's going to be considered infringing. Then YouTube might cite you for copyright infringement, for a strike for copyright infringement. And I think after 3 strikes, they take your page down. I'm not really sure. Each social media platform has their own terms of use and what you can post and whether or not you can post a cover or something like that. So I'm not really sure about many others, but
I guess maybe I'm a little bit more scared of getting sued, rather than by the owner. So, for example, a Marvin Gaye estate or something like that, more so than
they're not gonna come after. No offense.
Okay, then. What if it gets 1 million views? What happened?
So whether or not you're going to get sued. So we're gonna be talking. So let me
ask you, is this like for your, this is, you're not monetizing this, so this is not for a commercial purpose?
That's a difficult question. I don't have a lot. I clearly don't have a lot of followers now, but
Right.
let's say it sort of goes into the algorithm and all of a
Right.
sudden, it picks up speed, and so then I'm like, well, I'm gonna collect the money if I can.
Right. But likely YouTube is not going to give you any money from something that's
Fair enough.
that's somebody else's type of work.
Okay.
And so you're not going to be able to so if it's generally, that's going to be for like a non-commercial purpose, because to me that's you doing that for fun.
Mm-hmm.
And if it's for a non-commercial purpose, it's not, it is copyright infringement, but you're not making money from it. So there's gonna, you can be not sued, but you can be you can be cited for copyright infringement in that case, because you are infringing. But there is a limit as to, if someone wanted to come after you, they would, the limit in Canada at least is $5,000 if they wanted to, and that's somebody that's someone that's private, that's infringing for a non-commercial purpose. I think the lowest is like $100. So it's up to you whether or not you want to take on that risk to post work that you're not monetizing out there and using somebody else's copyright infringing work.
Okay, that makes sense.
Thank you so much for the questions. And just as a quick follow-up, Diane, I'm sure, because I see this sometimes, posting, I am not the owner and I do not own the rights to this. Does that do anything, or?
No, so that's a great question. I always, as I was speaking before about like the rights of attribution, like whenever you are using someone else's copyrighted work, it is just generally good practice to make sure that you put their name, or you make sure that you do put the disclaimer that you don't own the work and that this person owns the work. So it kind of shows that, you're not intending to steal it and pass it off as your own.
Right.
You're putting it out there that someone else owns it.
So it's good courtesy.
It's good courtesy to do. Yeah.
Okay.
But if they
awesome.
do contact you and ask you to take it down, that's also good courtesy.
Okay. Awesome. And I was going to ask, because I know we kind of got into social media, but I was just curious, and you may have to really dig in. Obviously, you did say that each platform is different, but I know like platforms like Instagram and TikTok in particular are very musicians do a lot of
they do.
Posting and things like of that nature. And so I'm curious, because I know that when you talked about the four
rights
in the song, and so one of them was kind of like the label you mentioned, right?
Yeah, the maker.
And so I'm just curious, like, are these platforms, it's just a question, like you may or may not have an answer, but do these platforms have any right to the thing that you posted just by you posting it on their platform?
Normally, no. So for instance, Instagram, normally if you post a picture or a video or normally they don't claim copyright in your work.
Okay.
So normally, no, they're not gonna claim any copyright in your work.
Got you. Okay.
It's still so there's usually for Instagram, and I know TikTok, they usually have, if you read their terms of use, it says that any copyrighted work still remains with you. You're still the owner.
Okay. Awesome. So they're not coming for you.
No, they're not trying to take your work.
Okay.
They have enough.
But
troubles.
you posted it here first, so
But
no one knew it before us, right?
Yeah,
It's
exactly. But I mean, just speaking on that topic, people do like to steal people's copyrighted work off Instagram and other platforms. And so if you can, I'd just always say try to put that that copyright symbol, just the copyright notice, try and watermark it if you can in your work to make sure that people are on notice that it is copyrighted work.
Got you.
Yeah.
And I probably will ask this last question unless there's others. But kind of on the topic of social media, because I've seen this a lot, wherein it I think we kind of got into the question a little bit, but maybe there's a little bit more, wherein, someone might post something as let's say I post a video of myself playing a guitar part
Mm-hmm.
that I came up with, and I
Mhm.
just liked it, and I
Mhm.
decided to post it.
Mhm.
And then typically, what would happen if folks think that it's good and it's sparking imagination and creativity, a friend or maybe even the stranger,
Original guitar part.
your original guitar
Okay,
part
go
that you
ahead.
came up with,
Mhm.
a friend or a stranger might like just create another video with your
Yeah,
video.
mashups.
Yeah, and like say, hey, like we're playing now. My guitar has like a keyboard part.
Yeah,
with it
I
now,
see that's a
and
lot too.
It
Yeah.
happens all the time. So I'm just curious, like thoughts on that. Like, are you like what's going on there in your mind, or what are you seeing in that?
In my mind, that would probably like be considered a remix or a mashup.
Okay.
And
Okay.
so especially when you put it on a platform and you kind of, and I've seen people like invite people to play on it,
Right.
sing on it,
Right.
do your parts on it.
Right.
A lot of you have there. So copyright is a balance, right? You want to protect people's work and protect their right to monetize their work, but at the same time you want to encourage creativity,
Right.
and you want to encourage
Absolutely.
people to be a community and come together.
Right.
And so there's a balance as to whether or not someone goes after someone for copyright infringement. So normally, because that's not normally monetized, I would
Right.
say that's okay, and it's
Right.
not copyrighted, and it started out with original work and somebody putting a layer on top of that.
Right.
Maybe they're putting original work, but
Right.
I wouldn't say that anyone's infringing by taking and especially
And
when you invite them to.
Got it. Interesting. All right. No, this is really good. Any other questions, Dan? You've been fantastic. You've been here on the hot seat for us,
Man,
but just you've been
I
doing
tell you.
you've been doing a great job. Are there any other questions? I know we're sort of getting to the end here, but if not, doesn't look like it. Wow. Well, you know what, Diane? Thank you so much
Thanks, Joel.
for coming all this way and sharing with us. Yeah, let's give Diane just a huge hand, a round of applause. Bravo, well done. I'm sure that the information you provided today is going to help a lot of folks that come through our doors, and we've recorded the whole thing, so I'm excited to see how we're able to use this for educational
For educational, not
purposes,
legal
right?
advice. Educational purposes.
And so and of course, if folks do need some legal advice, you did point them in
Yeah.
the right direction, and I'm sure folks can also get in touch with you on a case by case basis as well. But thank you so much, everyone, and if let's if anyone doesn't have any other questions, thanks for coming, and we appreciate you so much. Have a wonderful rest of your day.
Thanks
Thank
so
you,
much,
Diane.
Joel.
Appreciate it.